morning, everyone. I'm Nupamat Thamathiradecho.
Many things I want to say. Only two of us.
I'm the moderator for today's webinar and also the one of the speaker. And today we would like to present the Thai Arbitration Institute's webinar series on the international construction arbitration. We are very delighted to have the two distinguished speakers today. So first, I'd like to introduce, I think that better introduce Mr. Phuntok Wangdi. He is the former General Public Prosecutor of Bhutan, and he graduated Bachelor of Arts from University of Delhi, India, and also the Bachelor of the...
My paper on the... Huh?
Yes, and also the Bachelor of Law from University of Mumbai, India, and also the Master degree Comparative Law from the University of Adelaide, Australia. And Mr. Wangdi will provide you the presentation on the claim and dispute on the construction. And then I would like to introduce our distinguished speaker from Hong Kong, Mr. Wesley Pang. He is the partner of Global Litigation and Dispute Management Group of Everchase, Switzerland, and he now working in Hong Kong. He has several experience in the international arbitration as well as in investor-state disputes concerning various institutional rules. So today he will talk on the construction dispute and ISDS. I think that for myself, I will talking about the construction claim for extension of time and additional cost due to the COVID-19 pandemic. So for today, we will have the presentation from Mr. Wangdi, and then we go to Wesley and myself. We will talk on the topic, and after that, we will open the floor for you to raise the question. For the participant, you can use the box on the panel and type in your question to us, and at the end of the presentation I will read your questions to the speakers. So right now I think that I give the floor to Mr. Wangdi to give his presentation.
And quick share. This one.
Yes, Mr. Wangdi, you can.
Okay.
It's your floor now.
Okay, now good morning, everybody. I'll be talking on the construction contracts, and mainly based on the hydropower projects, because since I've been when I was in Bhutan, I was working and as a board member in the hydropower projects, and these civil construction activities are very complicated, and since it involves many components, and also especially like we have these hydromechanical issues, then electromechanical issues, then civil activities, and because of the difference between what is provided in the contract and then on the ground reality, it sometimes it differs and new items comes up, and because of that, lot of issues come up, and to solve all these issues takes lots of time. For that, I want to share the experience so far whatever I have been serving as the board member. So firstly, I'll start with the contract management in this civil contract activities. So as I've already said that the first thing is the main thing is on the follow-up of the contract or contract management. As I said, it is very cumbersome and difficult task, and that's why I think for that we need to have good committee members, board members, and ultimately, if there is an arbitration clause in the contract agreement, we need to have good arbitrators. If there is no arbitration clause as such, then ultimately it goes to the court, and in the court also, it becomes very complicated. So that's why I want to share some of the experience which I have gone through. So it needs a detailed foresight. I think, especially when they prepare DPR, they'll have to really infer things beforehand, and it is very difficult because everything is underground, and because underground things can change now and then. And for that, there has to be an advanced action, both from the contractor and the employer. And even the contractor will have to make a site visit and infer many things, because before he bids for the work, he'll have to see ground realities and all. And sometimes he cannot see many things under the ground. And that's why sometimes even the contractor will make mistake, and whatever he has bid in the amount may not match with the ground reality cost. And that's where these variations, new items come up. And when there is variation, new items, then to come up with the new cost, new formula, and of calculating the costs becomes very difficult and very controversial. For that, I think both the parties must be unbiased and must have an open-minded. And if the both employer and the contractor, if they are open-minded and if they focus to the project approach, then it will be good for both the parties and ultimately for the project, which is for the public interest. So both the parties to the contract must perform their parts properly. This is very important. So I'm just speaking on behalf of the employer and also the contractor. So if we don't work hands in glove, then no small issue can become big issue, and because of that, and sometimes the work could be delayed, and thereby there will be loss for both the parties. So therefore, the contract management actually is an art. It is an art, and the way we require skills, and it's a science of managing the contract to get the optimum desired results in fulfilling the targets of the project. So that's why the contract management in the civil activities, especially hydropower, is very complicated. This is what I want to share. So therefore, both the parties to the contract must be aware. They must be aware of their obligations. It's very important. Their responsibilities, duties, and rights under the contract, which must be shouldered with eagerness. So if there is no cooperation, if there is no understanding between the parties, small thing can become big, and this will affect ultimately the work. And that's why the contract management is very sensitive. So I want to share some of the uniqueness of construction activities. As I said, that the ground conditions and weather, these are one of the main factors which affect the work, which will bring variation in the work items and brings more complication when the work is awarded and the work is implemented on the ground. So every construction contract is uniquely related to a particular site and ground conditions, which may not be fully defined or predicted when the work is designed and awarded. This is what I've already said before. So we cannot see everything, we cannot forecast or foresee everything beforehand. That's why on the ground reality, when the work is implemented, things change. And because of that, the construction things, especially the underground activities, are very unique. And for that, I think a lot of skills and a lot of experience are required, not only from the employer side, but even mostly from the contractor, because they are the one who will be taking the real work on the ground. And I think the contractors must have good experience in taking up these activities. Despite the modern methods of site investigations, uncertainties exist throughout the operation of contract. So, of course, like the employer, when they prepare the DPR, they engage a lot of like modern methods and technologies to do the site investigation. But still, then after that, when the work is really taken into hand and when there is an execution of the work, so many things will come up, so uncertain things will come up, and that makes the contract very complicated. So therefore, the construction work is continuously exposed to weather and is subject to its constraints. So one other thing is that because of the geological situation and the condition, and also the weather condition, because of all that thing, the underground the underground scenario changes now and then, and because of that, the things change. For that, a lot of new items will come up. So most of the claims arise out of above uncertainties. So as I said, there are uncertainties. So and because of that, when you do the ground operation work, uncertainties pop up, and that leads to dispute. If the work is as per the drawing, as per the plan and activities all on the paper, the disputes may not arise because then the rates have already been established and the amount of work will be measured by joint verification and payments will be made. There may not be many disputes. But when there is variation, when there is change in the work, and because of that, the disputes will arise. So in the construction industry, despite the best intention of the parties, disputes are unavoidable. It comes up because parties don't want to have all these changes in the work, but these are unavoidable, which is due to large number of uncertainties, as I've already said above. So provisions for settlement of disputes are laid down in the contract agreement. Of course, there are many provisions laid down in the contract for the uncertain things or for the regular work, but still then these provisions may not cover up well in resolving the issues. So for that, extra effort is required. Disputes implies an assertion of a right by one party and the reputation by the other. So actually, the disputes are usually raised by the contractor, and then when it's raised, then the employee usually will be repudiating that, and because of that, then the dispute becomes more complicated. The reputation may be either expressed or implied, or by words or through the conduct. So usually the contractor will always submit their claims or their disputes in writing, but sometimes the employer, having some advantage, may not give immediate response. They may just simply give a mere words or maybe through a gesture, but the contractor will pursue to give everything in writing, and that way sometimes the actions are delayed, and that leads to more complication. But mere silence may amount to repudiation in many cases. Sometimes the employer intentionally do not respond for many purposes. This is what I said before. Sometimes the employer will intentionally they will not respond on the issues because they are expecting or some other thing which may get resolved by itself, but it doesn't, and because of that, issues come up. Disputes which are capable of reference to arbitration must necessarily arise in respect of a defined legal relationship. So if there is an arbitration clause in the contract document, if that has to go to the arbitration, then I think that has to be covered by the contract document. If it is not covered in the contract document, then it may not be covered up. So for that also, we have to be very careful if you want to proceed the disputes through arbitration. Then it's very important to have good arbitration agreement or exhaustive clause in the arbitration agreement. If that has to go to the arbitration, when it is processed to the arbitration. So now these are the causes for disputes. The first thing is inadequate preparation by both the parties before inviting tenders and after awarding the work. Sometimes the employer will also have many shortcomings by not including many things in the contract, and the contractor not doing the site inspections properly, and because of that, when the work is carried out, the cost escalates or new items come up, and because of that the issues will be raised by the contractor, and it takes a lot of time, because changes in the changes in the extent and details of the project by the employer after the contract is awarded and commencement of the work. So I mean to say here the variation. There is the change in the extent of work. There is the change in the details of work. And sometimes because of the change of the policy, especially if the employer is government, because change of the law or change of the policy, then sometimes they also order for new items of work. So when the new items of works are ordered to the contractor, especially by the site engineer, then for that there is no cost or rate being fixed in the contract agreement, and because of that variations come up. So second is delay in making decisions by engineer in charge or employee, which may lead to idling of contractors, equipment and overhead cost. Sometimes delays are usually occur due to late decision by the engineer in charge. The engineer in charge sometimes cannot make decision immediately on the spot, and he or she may not take risk. And if that is not within his or her power, they will simply forward it to the management. And in the management, there are committee members. And sometimes, all committee members are not there, and all that bureaucratic channel and red tapeism takes time. And by the time the contractor is might have to idle their equipment or their resources, and because of that, the other claims might come up. So for that, there has to be a good mechanism in the contract document to solve all this. And sometimes due to bad or weak conditions in the contract. So even if there is a provision in the contract how to resolve this dispute, but sometimes the provisions of the contracts are vague. There is ambiguity in it. If there is ambiguity, again there is dispute in interpreting. So because of that, it will take a lot of time, and work has to be completed on time, because mostly works are time based, and because of that more complications come up. So these are also one of the causes for the disputes. Then other thing is that unworkable quotations with the contractor, where the new rates are determined for new items of work. Sometimes even if the work, the new item of work or variation has been agreed, but the quotation or demand by the contractor could be like unimaginable, and which may not be accepted by the employer. And because of that, again, the dispute will arise. It will take a lot of time. So all these things, I think both the parties must keep in mind, because ultimately you have to be practical on the ground, and for the interest of both the parties and ultimately the project. That I think both the parties must keep in mind. And sometimes on the personal ground, the mental setup of the parties or by the parties representative will also complicate the things. So therefore, for that reason, there is a need for speedy dispute resolution. It's very important. So in the civil contract works, both the parties are supposed to be equal. Yeah, that's, I think, ultimately for universal, the principle that all should be equal and no one should have a superior power to somebody. If you have that attitude, I think you can solve the problems. But the nature of civil engineering work and the contract is such that employer has upper hand. Yeah, usually actually employer seems to have upper hand, because since they are the agent who is paying the money, they are the one who has drafted the contract document, and then they ultimately when to pay and how much to pay. Ultimately, then they have all these bureaucratic channels and all that thing, and usually the employer delays the payment, and also they also delay in making the decision, and that ultimately makes the simple disputes very complicated and ultimately very costly, which affects the project. The condition of contract generally provide that, okay, despite the dispute, the work must proceed as per the program. However, if a dispute remains unresolved for a long time, the completion of the work is bound to be affected. So the contract, one of the provisions in the contract is that it says that the work must go on, the work must proceed as per the program. And however, if a dispute remains unresolved, so work must go on. They are not paying the money. The decision is still going on. It is not finalized. But despite that, the contract says that the work must proceed. But if such things are unresolved for a long period of time, more complications are going to come. There will be escalation of the cost. So then, because of that, contractor may not have enough money at hand to carry out. If that particular money is blocked on the way, and if that money is not paid, and if the contractor has to proceed with the work, then since his money is not paid, that like first running bill, second running bill, if it's not paid, he may not have enough money at hand, and that will ultimately delay the work, and that will cost time and money. If there is no inbuilt resolution mechanism for resolving the issues in the contract, the only resource is to file a case before the court of law. So if there is no arbitration clause, like if there is no negotiation or some other mechanism, ultimately then the case will be forwarded to the court, and that is going to take more time. And due to that, there will be more complications and the project cost will go up. So due to huge workload before the court, this is one of the reasons, resolution through it will take long period of time. Therefore, it is important to have effective and inspiring mechanisms in the contract for speedy resolution of the disputes which arises in the course of execution of the work. So for that, I think the effective mechanism has to be planned long time before the dispute arises in the course of the work. So if these things are not done, this is what we are going to face. So both the parties are not happy, and because of that, there could be more complications, and ultimately the project's interest will be affected. Both parties will be affected, and this is how it happens. Usually, usually the contractor is not happy with the decision or not being able to resolve it effectively. This is how it gets into thing. So that's what to resolve the conflict at the earliest and to resolve it favorable for both the parties, the contract document has to be drafted well before it is implemented, so that we have win-win situation at the end of the day. So actually now these are the claims. From the dispute there will be the claims, and claims they are inescapable component in almost all the construction works. They will come. Claims are going to come. Claim for the regular work, claim for the new item of work, claim for the variations. So this all will come, and successful claim may turn into fortune sometimes for the contractor, or in different processing may be sufficient to turn the profit into loss. Sometimes if there is a wrong method of doing the calculation, the contractor can run into losses, and sometimes he can also get the profit or benefit out of it. So claims may be negotiated. Once the claims come up, it could be negotiated, amicably settled, or may lead to arbitration or litigation. Ultimately, these are the two ways of resolving it. So claim is a request made within the existing contract. It can be beyond for additional payment. So claim could be for additional payment, for additional time, or sometimes it could be for both, for the agreed additional task, for which the existing contract does not provide provision. So sometimes there will be no mechanism to solve this. Then, as I said, it could be for time, money, or both. And claims could arise due to change in design. Yeah, this is change in design. This is change in design means sometimes because of the policy or ground situation that the drawing has to be changed. Because of that, there is variation, change in working circumstances, the underground situation changes, and changes to the contract conditions. Based on this, there will be also change in the contract conditions. So then disputes could arise on the, one of the issue is that on the measurement of the work done. So that method of doing the measurement, sometimes the employee will say, this will adopt this method, the contractor will say, we'll adopt that method. This is for new works. For the regular work, the measurement the things are already there. There's no problem. But for new work, when there is a measurement being decided between the parties, and there will be a big issue on that. So dispute could arise on determination of rates. So even if the measurement is finalized, but then second thing is to decide on the rates of the item of the work. And there also they may not agree, and that will lead to complication. So dispute could rise on the determination of price escalation. Yeah, sometimes the certain the contract says that after 1 year or so, or 18 months, you get the price adjustment because the prices of the components of project changes in the market. But again, there will be also differences in the calculation of the price escalation. Then the recoveries usually happens are with the rebate. Sometimes the contractor will offer the rebate and that will be deducted. Then all the advances given to the contractor will be also deducted. And sometimes the employer also, to facilitate the contractor, they also supply the materials or equipment in the beginning, and later on they will also recover the cost for all this the supply is made by the employer. And if there is a delay in payment of the work in progress, including the running bills, there could be a delay in this. There could be a delay in payment of the final bill. When the work is done, the final bill is not released, and that will also create complication. Delay in the release of the bank guarantees, because the bank guarantees offered by the contractors are not released by the employer because they have not solved their differences, and they try to adjust that through bank guarantees, and that leads to complication. And security deposit and the retention monies which the employer deducts are sometimes not released on time. And because of this, if there is a delay, if there is delay by the employer, a lot of implications are going to come up. That is going to lead to idling the resources of the contractor. The contractor's idle resources are idle, and that will also cost money. Idle for labor, staff, machinery, collected material, overheat, whatever. And because of that, later on, contractor might ask for idling cost, and that will become more complicated. And advances paid to the suppliers, because now they've already paid advance to suppliers. Now they cannot take work because of delay by the employer, and because of that, there will be loss of profit or opportunity for the contractor, which they might claim later, and which is going to be usually huge amount. Then, if there is a non-performance or delay by the contractor, then the contractor will be liable for liquidated damages as per the contract agreement. Then there could be a forfeiture of security deposit to adjust the money, and their bank entity could be also forfeited. And risk in the rise of the cost of the balance of the work. If the work has to be offered to some other bidder or some other contractor, then usually the cost will go up. And then who's going to bear the cost? Is the contractor or the employer? So that will also become very complicated. So ultimately, if both the parties don't perform their duty well, there will be a loss of revenue. So these are the mechanisms for the resolution of the problems or the claims or the dispute. Firstly, on the ground, it's the site engineer who has the first-hand authority to decide matter on the spot. He's given certain power, but the things which are not within his power, he can always refer it to the management. Then in the management, there is a committee. They will sit, and the committee will decide on how to do it. And usually here it takes time, because sometimes the committees are it takes time because committees have a lot of responsibilities and they cannot come on time. And if if the committee cannot resolve, then they go for amicable settlement. So they try to negotiate with the contractor. And sometimes they also establish dispute adjudication board. So before the case goes to arbitration, they try the case through this board. And if then after that, if parties are not happy, then they can go to the arbitration for further resolution of the case. If there is no arbitration clause, it will go to the court of law. So before arbitration commences, the parties shall attempt to settle the disputes amicably. This is what they try to do as much as possible to solve within themselves. So amicable settlement has actually a lot of advantages if they take advantage of it and use on time, because the contract could have provisions for amicable settlement. And there, if they do well, they'll solve, they will save a lot of time and money. So it is a process. This is the process, left to the employer and the contractor, with the assistance of the engineer in charge. Yeah, in the amicable settlement, the engineer in charge must be there, because he is the one who has been on the ground. He knows every facts, bit and pieces, and therefore he should be always there to help the committee or the team whenever deemed appropriate. Sometimes dispute adjudication board could be constituted, as I already said, before the case goes for arbitration. And this DAB is very popular. It's a panel of 3 experienced, respected, and impartial reviewers. So it is organized before the construction begins. It's already in the contract document. And DAB is made, the board member is made familiar with the project details through documents and regular site visits. Once the board is constituted, they will be familiarized with the project by making site visits, and they will be informed now and then. Any unresolved dispute referred is deliberated by DAB. So after the committee has failed, or if there is no amicable resolution, then they will forward this case to DAB, and then DAB will deliberate. So pleadings will be made by both the parties, where they will submit the documents, and there will be also oral hearing, very similar to arbitration. And DAB recommendations are based on available data, practical experiences, and knowledge of the board members. So usually board members should be a person who has certain knowledge on a particular dispute, so that they will use their skills in resolving this matter. So the recommendations are given in writing by the board, and the enforceability of it will depend on the terms of the contract. Okay, if sometimes the contract says that up to this limit, it will be the decision of DAB will be final and binding. And sometimes they say that beyond that, it could be able to the arbitration. Sometimes they say that the arbitration, the decision of the board will be final and binding, of irrespective of any amount. So this is how they stipulate the provision in the contract. In case the recommendation is not objected by either parties within certain given period of time, the same shall become final and binding. So these are how the provisions will be incorporated in the contract document. So DAB proceedings can be brought as an evidence before any tribunal. So if the parties appeal for the arbitration, then later on the decision of the DAB, this board member, can be used as an evidence before the tribunal. And the tribunal normally shall not go against the recommendation of 3 experts who has the knowledge and experience of the trade and are known for their reputation. So usually the tribunal will also honor the decision of the DAB. So for that period, for that reason, so far whatever I've done as a board member, we have seen that parties usually don't appeal against the decision of DAB, because even the tribunal will, it's almost like they will honor the decision of the DAB, because these are the senior people and they will make very less mistake, and they take time and they make good decision. So going to arbitration will be extra cost. So usually people don't appeal against this DAB. So DAB doesn't take time also. So this DAB has been very effective mechanism in resolving the problem. So they are duly accepted by both the parties at the start of the work. So this DAB should be accepted by both the parties before they start the work. The matters considered by DAB rarely go for arbitration. Yeah, this is what I say. the both the parties rarely appeal against the decision of GAB. So the decision of the GAB discourages actually raising unjustified claims by the contractor and encourages the employer to accept the justified claims of the contractor. So that's why the GAB is very, very fair, and therefore both the parties are usually happy with the decision of the GAB. So this GAB is appointed, GAB members, each party will appoint one, and then they ultimately they will also appoint the chair. The third member, which is the chair, is nominated by two appointed members, which is duly accepted by both the parties must accept. Two appointed members will appoint the chair, and that chair should be accepted by both the parties. So it's very similar to arbitration, but it's very effective, it takes less time, and it's very decisive, and it doesn't take time. Therefore, GAB has been very effective. The members are expected to be a person with knowledge, experience, and reputation. So you have to be thorough with your job, and that's why it saves lots of time and cost. They should be, the GAB should be like arbitrators should be impartial. They should be fair, neutral in all situations, and the parties should have confidence in them. So GAB member, when they appoint member, I think they have to be very selective. Then if there is if there is arbitration clauses there, and if people want to go for arbitration, then the normal due course of arbitration follow. Usually each party nominate one arbitrator. The two selected will then they mutually select the third, and all proceedings, decisions, occurrences, testimonies, and decisions are all recorded. It takes a lot of time. It's almost very similar to proceeding case with the court. Many times there are delays in taking decisions. Now we even arbitration has become quite expensive and takes a lot of time, which leads to time and cost overrun of the project. So even after the decision is taken, execution of the decree or the award may take a long time. So the arbitration is also becoming very costly, and for that very reason now the TAI, the Thai Arbitration Institute, we are introducing now the e-arbitration, online arbitration, and we are also now revising our whole rule. And and we have also come up with new rule for online arbitration, for e-arbitration, and within that we are also going to come up with small claims, hybrid arbitration. So first we try with mediation, and if not doesn't work, then you try with arbitration. If mediation works, then the arbitrators can honor that as an award, so to save time. So we are working all this, and for that we have also invested so much of money for the technologies. And also then we have also come up with new facilities in our institute, and we are really working hard because of this the pandemic, people cannot go out, and for that now mobile arbitration on the ground has become expensive. So now to save time, we are working hard, and very soon we will upload the e-arbitration rules on the website. Our main rule on the website, and all the facilities will be informed well to the clients and to the arbitrators. And we are looking forward. We are also forging partnership with some other centers so that we can work hand in hand and resolve the issues at the earliest. And firstly, we are targeting Southeast Asia, and then ultimately to the entire world. And we are trying to. And we have already collected good experienced number of arbitrators on our list. So if people can take advantage of this, and that effective mechanisms are going to come up, and I would like to appeal to all the clients and business partners to take advantage of our institution, because we have the advantage of being part of the judiciary. And for that, I think since the arbitration, in the arbitration there is involvement of the court, and that we can facilitate to be faster. After that, again, to implement the award, I think we need to have a court. For that also we can facilitate. And for that, we have this extra, the avenues to resolve the arbitration at the earliest. For that, I would like to request all our clients to take advantage of our TAI, and we want to become one of the best arbitration centers in the world. So with that, I would like to thank all our audience and listeners and the organizers for giving me this opportunity. And I would like to also thank my institution for giving me this opportunity to do this presentation on behalf of TAI, also to judiciary. Thank you so much.
So I think that you already give some brief to the participant. I think right now we like to give the floor to you, Wesley. I will upload your the presentation now.
That works for me. Thank you very much.
Sorry about that.
No worries at all.
Okay.
Why don't I just start to say that I'm very grateful to be here today to be giving this presentation. I'm also very grateful to the organizers, TAI, Tilleke, Gibbins, and our esteemed moderator for sort of marshaling us along today. What I hope to do is to give a brief overview. I'm also very happy to sort of pick up the conversation in a subsequent discussion or a subsequent conversation over investor state dispute mechanisms, or ISDS, and how they may relate to sort of construction disputes. I think that this is a topic that has garnered or received quite a bit of attention over the past 4 or 5 years, especially in the Asia Pacific region, and I think more recently in relation to sort of those in Thailand, in terms of cases that are arising in South Asia, Southeast Asia, and North Asia and East Asia as well too, involving various states and investors from different jurisdictions. I think uniquely, we had been talking about giving this webinar, presentation, which was meant to be an in-person presentation. Our discussions on this started probably earlier in the year. We had planned it for later in the year on hopes that the situation with COVID and sort of the pandemic would sort of subside and we might be able to travel again. But as we were just talking about in terms of virtual arbitration, I think we've been taking advantage of the technology that we have in order for many of us, Mr. Wang Di and so forth, and myself, to sort of give this presentation and also to meet everyone who are on this sort of webinar and talk about some of the issues that are facing us. And I'm also myself looking forward to the presentation after mine that'll be given by a moderator in relation to sort of construction delay and sort of extensions of time, which is something that I think many of us are quite familiar with, but also sort of interesting to sort of talk about in this forum. So as I said, I'm going to give an overview. I plan to talk about 4 areas. I'll probably give a brief introduction to sort of ISDS, as I said, investor state dispute settlement mechanism, the history of it, sources of law. Second, I'll talk about the sort of the nexus between construction disputes, where we do see construction disputes arising within the context of ISDS arbitration. And then I'll talk about some of the issues that are unique to ISDS. And then I'll talk about the future, some of the sort of issues or backlash that have arisen with ISDS, but then also talk about some of the sort of reforms and sort of to deal with some of these issues. So I'm turning to slide 3 of my presentation. I don't know if that's coming back on the screen. Here. Yeah, so I'm on slide 3. Sorry, just back 1 slide. Yeah, sorry, we've gone ahead. Here we are. So this is just to give an overview of ISDS. It is sorry, just 1 second. Yeah, so here we are. My apologies. So ISDS, as I said, is an investor state dispute mechanism. So what we were talking about in Mr. Wang Di's presentation is very much contractual or dispute resolution that was provided for by the parties, specifically expressly in contracts, whether it be EPC contracts, contracts based on FIDIC or NEC, or any sort of bespoke arrangement. You also find them dispute resolution, as Mr. Wang Di talked about. You also have them not only just specifically in construction disputes, infrastructure contracts, but also in terms of O&M. So any operation and maintenance sort of contracts will also be very similar, and many of those on this webinar will be familiar with those. What I'm going to talk about will step away from sort of agreed contractual arrangements for the resolution of disputes and move into sort of the plane of international law or international economic law or international investment law to talk about mechanisms that actually are struck between governments. And that source of law comes from international instruments, international treaties, whether bilateral or multilateral treaties, typically in the context of free trade agreements or specific investor or investment protection treaty agreements. So in a nutshell, ISDS can be defined as sort of a mechanism where foreign investors resolve disputes with the government of another country where they have made an investment, which we will call the host state, in a neutral forum through typically final and binding arbitration. So these type of agreements, and this getting to sort of the sources of law, are commonly found in either international or bilateral or multilateral treaties that are entered into between governments or sort of sovereign states, but may also be found in domestic legislation as well as also specific contracts. The contracts that you may be familiar with in this in this area, especially in the technical field, are power purchase agreements or PPAs, and maybe also sort of PPP agreements, public-private partnership agreements may also provide for them as well. The instruments are typically set out, and I'll come on to this in a little bit more detail because it relates to sort of the claims that Mr. Wang Di was talking about in a contractual context. And then in a treaty context, we talk about substantive protections or obligations that are owed to foreign investors operating in a host state, and the breaches that give rise to sort of treaty claims that may be claimed against or brought against the host state. So I think that it's very good and sort of for the way we've juxtaposed this presentation to come after Mr. Wang Di's is because we've been talking very much on a well, I guess what we would call commercial level dispute resolution, the commercial level between two commercial parties, two contracting parties in the context of a project, whether it be the construction of a toll booth or an infrastructure project related to a mine, for example. These are sort of, and many of those on this webinar will be familiar in terms of negotiating those agreements, putting in, as Mr. Wang Di was referring to, sort of multi-tier dispute resolution clauses where you may have pre-arbitral negotiation, engineering determination, pre-arbitral adjudication, and then DABs or dispute adjudication boards, and then finally, and upon dissatisfaction, the ability to refer something to an arbitral tribunal or an arbitration, either ad hoc or an institutional arbitration. I think one area, so what with ISDS, as I just gave in the definition, we move from that commercial plane to an international plane because we are now talking at the level of foreign investors and those with foreign governments. Traditionally, the ability of a foreign investor to bring a claim or grievance against another state, a host state, for example, very limited instances, and certainly were not able to be brought in their own right as the foreign investor. So this goes back, I would say, a few centuries, and the traditional sort of understanding of how one would seek dispute resolution at this level in public international law would be through diplomatic protection. So those may be familiar with sort of under the rubric of the United Nations. There's the International Court of Justice. There are also sort of other sort of tribunals and special tribunals that have been set up, or commissions that have been sort of established to deal with sort of some of these dispute resolution processes. In this context, a foreign investor would traditionally need to petition its own home country. So if I was a Thai investor and I was operating in Malaysia, for example, and I'm just using examples here, I would need to go to the Thai government and ask the Thai government to take up a claim on my behalf as one of their nationals or their citizens to then bring the claim against Malaysia. But that would be done at a government-to-government level. So, and from a jurisdictional point of view, if you look at the statute of the International Court of Justice, you were talking about sort of state-to-state dispute resolution, and a foreign investor wouldn't have standing, or a tribunal wouldn't have jurisdiction to hear agreements at that level based on sort of how the statute of the ICJ is established. So you're left with what we call, and I have it on the slide, before the advent of ISDS is sort of diplomatic protection. So basically, Thailand, the Thai government would be exercising diplomatic protection in trying to bring a claim directly against Malaysia. Now, I guess that what it means for the Thai investor, the Thai company, the contractor, for example, if we put it in the context of construction disputes, is that it's no longer really the claim of that particular company or contractor. It's now the claim of the Thai government and the Thai state, the Kingdom of Thailand, to then bring the dispute against the other state. In this case, in my fact pattern, it's Malaysia. Many of these, there are various interstate treaties that have been around that have sort of allowed grievances in terms of sort of foreign investments to be resolved at an international level. Some of them go back to sort of the inception of the United States, going back to the 18th century. Many may be familiar in public international law contexts with friendship, commerce, and navigation, or FCN treaties. There are quite a few of FCN treaties that have gone to international dispute resolution, including before the ICJ. Electronic Silica versus Italy in the 80s and so forth is a clear example of an American investor through the United States exercising diplomatic protection to then have the U.S. government then bring a case against Italy, which then went before the International Court of Justice on the basis of some of these treaties. So, there are quite a few around here. I think so historically, what then happened after the Second World War, while institutions like the ICJ were sort of established with the establishment of the UN, we also saw an evolution of investment protection treaties. So moving away from these interstate dispute resolution contexts, we now saw in sort of modern treaties, or what we will call modern treaties, allowing for what we are calling ISDS. Basically, an investor can bring a claim without using diplomatic protection and bring it directly against the host state. The first of these treaties that was established was in 1959, and that was between Germany and Pakistan. So it's very interesting that, and I'll get on to, in terms of dispute resolution, Asia or Asian states have actually played a pretty important role in the development of ISDS and some of these bilateral investment protection treaties. So this was the first, but certainly not the last, as I've indicated in the slide. But the growth of these investment treaties, and I'm speaking specifically about the bilateral ones, just in terms of reference points, but we should not forget that there are also multilateral treaties, and I'll talk about that in my bullet point in relation to Asia. So by 1989, which is sort of just 30 years on, there still is only 500 bilateral investment treaties allowing for investment protection for investors investing in sort of countries abroad. But in the 80s and 90s, well, certainly coming into the 90s, we saw a significant uptick and surge in states entering into bilateral investment treaties. So I would say between 3,000 to 3,400 bilateral investment treaties are in existence today, and these are just the bilateral ones. I'll talk on a little bit about multilateral ones. I think what's important and interesting in the context of some of these bilateral investment treaties is what necessarily is the rationale. Why are states entering into them, and what does it mean for investors? I think that there are, and I'll get onto a little bit in terms of when we get to ISDS and substantive protections. I think there is certainly, from an economic standpoint and from a trade point of view, allowing some states, in terms of economic rationale, in order to attract investment into their country, wanted to give assurances in terms of how they were going to protect foreign investors' investments in their country. And foreign investors are certainly looking for those types of protections when they're sort of looking to invest in particular areas. And I think that when you, another sort of important example, and this may be sort of partly the reason why certain jurisdictions have more bilateral investment treaties than others, is sort of the whether they are a capital importing country or a capital exporting country. Many of the capital exporting countries are certainly in Western Europe, United States, and also East Asia, in countries like Japan. There aren't necessarily that many treaties that are sort of entered into. So if I go on to my last few bullet points on this in terms of Asia, there's a large amount of BITs that are being signed. So in 2008, UNCTAD, which is a UN trade development body, was tracking sort of bilateral investment treaties and so sort of how these treaties come into force. 41% of them are from the Asia and Oceania states. So that's about 1,100 BITs. To talk specifically about Thailand, it has about 42 bilateral investment treaties, either enforced or have been signed. I've also provided some of the major trading partners with Thailand to show how many treaties each country has sort of entered into. So the United States, I'm not surprised. United States, Japan, and Singapore actually do not have that many bilateral investment treaties. And there's particular reasons for why that is. Some of them are sort of economic, and some of them are maybe more geopolitical. China may be sort of the, I wouldn't say outlier, but I would say that China has certainly had a very interesting program in terms of its bilateral investment treaty program, as well as in sort of free trade agreements. Many articles have been written about sort of the Chinese investment treaty program, and as well as books, and that certainly will be the subject of a presentation that I'll be giving in a few weeks' time under the guise of HK45 at HKC. But certainly it's interesting to see how China has developed and evolved its investment treaties over time, and I think that it's something that should be sort of looked to. In terms of what we want to, what may be seen in terms of outbound investment from these jurisdictions into other jurisdictions, including into Thailand, and what protections may be afforded those investors. But it's also interesting from a contractor's perspective in the area of construction disputes, as well as owner-operators when they're sort of especially in utilities that are operating in other jurisdictions, as to what protections may be afforded to them under this sort of rubric of different sort of investment treaties. In the multilateral context, before I move away from this slide, I think it's also worth noting, especially for those on this webinar, that there are sort of multilateral frameworks, not just bilateral ones between Thailand and Malaysia, Thailand and Singapore, Thailand and the United States. For example, I mean, it's also worth looking at in the ASEAN context. So obviously Thailand is a major economy within the ASEAN association. ASEAN itself in 2009 embarked on the establishment of what's called the ASEAN Comprehensive Investment Agreement, or Pact. And that certainly provides for investor protections or investment protections, but more ASEAN sort of from an ASEAN sort of geographical footprint across the different economies. And certainly Thailand is involved in that as an ASEAN member state. I'll come on to that a little bit more when I talk about some of the substantive protections that are certainly provided for under the ASEAN Comprehensive Agreement. I guess the other area are multilateral free trade agreements that have been struck recently and also over the past few decades that have been sort of the source of some of the dispute resolution in the ISDS context. I think many who are quite involved in investor-state dispute settlement, my firms as well as other firms are quite involved in this. You'll find that free trade agreements like NAFTA, so the North American Free Trade Agreement, which was, I guess I would be referring to NAFTA 1.0, the first iteration, which was struck in 1994 or entered into in 1994 between US, Canada, and Mexico. There's obviously now, which is NAFTA 2.0 or the multilateral, the MCA, between Mexico and the United States under the President Trump's administration. And then I guess more recently, there are multilateral treaty arrangements in the free trade context that have investment protections, and that would be around the TPP, the Trans-Pacific Partnership, which started out primarily with the United States at the front, but obviously, as many of you know, upon taking office, President Trump withdrew the United States from that arrangement, and it's now called the CTPP. 11 was 12 when it first was at inception. So it'll be interesting to see how some of these multilateral instruments that have investment chapters dealing with investment protections sort of evolve over time. So now I want to turn to the next slide. So this is slide 4 in my presentation. And I want to talk a little bit more in terms of sort of construction and the nexus with the ISDS. So as you'll see from this graph, which comes again from UNCTAD, which is a great source for sort of the evolution and historical background and statistics related to ISDS and these investment treaties. You see a very large uptick. Again, as I was saying, Asia's played a pretty important role when it comes to sort of ISDS and sort of investment protections. One of the first publicly known cases actually is AAPL versus Sri Lanka, with the award became available in the early 90s or 1990. But what we see, and what I pulled from the Isds website, this is the International Center for the Settlement of Investment Disputes, which is under the rubric of the World Bank, based in Washington, D.C. Isds, in terms of tracking its caseload over the years, looking 5 years back to about 2015, there certainly has been a steady rise in construction-related disputes or disputes that are categorized within the economic sector of construction and infrastructure. We see from about 9% in 2015 makes up the caseload of the Isds, one of the centers and arbitral institutions that deal specifically with investor-state disputes. And more recently, just last year, closed out with registering 17% of its cases in the area of construction. So it's very interesting to sort of see parties that traditionally had turned to sort of commercial arrangements for the resolution of disputes, as Mr. Wangdi was talking about, negotiation, engineering determination, multilateral dispute resolution clauses, and also providing for commercial arbitration. But we also see foreign investors looking to other forms or other fora for the resolution of disputes through the treaty context and looking at breaches that are not purely commercial. They may be commercial at one level, but they certainly have risen to sort of treaty breaches. And so that's also very important to sort of recognize this other avenue. Now, there are various ways of looking at how we get from a traditional construction dispute that goes up to a treaty arbitration. And I'll come on to that just in a moment in terms of talking about the substantive protections. But I think that it's worth noting that some of the issues that you may have in a commercial construction dispute don't necessarily fall away when you bring it to the treaty level. You still have to grapple with some of the issues that Mr. Wangdi was talking about in terms of you may be dealing with contract variation claims. We'll be talking about later after my presentation about extensions of time. Those issues don't fall away, and they can still make up the factual matrix of some of the claims that aren't necessarily brought as treaty claims, but certainly carry with it still a lot of the factual and evidentiary issues that come with a traditional construction dispute. So I just want everyone to sort of be alive and switched on to that and sort of what that means. It also they can still make up the factual matrix of some of the claims that layer of sort of international law that you also have to grapple with. But there are particular reasons in terms of the rationale as to why you want to look at a construction dispute in the context of ISDS. I think it may be because you're dealing in an emerging market or a frontier market where the commercial agreement for which you have entered into with a contractor, whether it's an EPC contract, onshore, offshore, an infrastructure agreement, the building of a particular facility in an area, it may be an area that's subject to particular volatility It may also be in a transition. So if you're in certain, I'm using different examples. Some people refer to war zones or coming out from sort of different sort of civil war conflicts and so forth. And that may mean that there's a question as to whether or not you can rely on the existence of local apparatus when it comes to sort of judiciaries and so forth, or arbitral institutions in a particular jurisdiction. So while we are familiar with commercial arbitration in and of itself, giving parties an ability to sort of move things from national courts into neutral fora vis-a-vis commercial arbitration, that there's a question as to whether or not you can rely on the existence of elevating one set of disputes into a treaty context, but then also taking the resolution of that also outside of the in situ or the immediate jurisdiction for where a project might be, and taking it to, in the context of ICSID, to the Washington, D.C. Convention, and also under ICSID for resolution under the World Bank rubric, or an ad hoc arbitration that may be administered by any one of the sort of leading institutions, including the Permanent Court of Arbitration, or institutions like the HKC, which have been dealing with investor-state disputes. The ICC is another example as well too. So it's sort of extricating yourself from the local jurisdiction. And so again, if you were a Thai investor, a Thai contractor that's sort of operating in a jurisdiction, and it becomes unstable, and you want to sort of, you are aggrieved with your investment, and you've suffered losses, but you don't want to, because of the current situation on the ground, you want to extricate yourself from that situation, and then you may seek to bring a treaty claim against that host state, and have it resolved out by arbitration outside of that jurisdiction. So now I want to turn on to the next slide, which is slide 5 in my presentation deck, and this really deals with issues that are more specific to what you deal with an ISDS claim. And maybe I can use this opportunity to also talk about some of the language that's in some of the Thai treaties, and certainly some of the language that's provided for in the ASEAN Comprehensive Investment Agreement. So Mr. Wang Di was talking a lot about sort of what we are familiar with in the construction dispute. You've got claims for extension of time, you've got claims for additional costs, final account claims, final agreement claims, dealing with subcontractors, dealing with engineers, design scope, contractor responsibility, owner responsibility. These are very part and parcel with dispute resolution in the construction dispute, and we're very familiar with some of the ways you would resolve that, as we were talking about in terms of adjudication, DAB, mediation, and so forth. When you are dealing in the treaty, it's the treaty itself. So you're moving away from a commercial agreement that was struck between contract party A and party B, and dealing with an investor, and an agreement and treaty protections that are provided by a treaty struck between two governments instead. So there are various forms of what we call substantive protections that are typically provided for in investment treaties. Protection against expropriation. So some of this may be regarded as nationalization. So for example, if the other state decided to take over the Thai contractor's construction site, commandeer the material, or to terminate the license or any of the permits provided to the Thai contractor in that foreign state, you may find yourself in sort of an unlawful nationalization or an unlawful taking or expropriation. So a treaty will protect against that, or will provide language where there's a lawful nationalization, that there must be compensation at a particular level, whether it's at fair market value or at market value. The investor will be compensated. So we've seen various examples of this in the Latin American context, certainly under the Chavez administration in his government. Many will have seen a lot of expropriations of foreign investors and their investments in Venezuela over the past couple of decades. So that's one area. I think that the next one I'm coming on to is full protection and security. Examples of this at its barest level, or the basis level, we're talking about physical protection. So this is the protection of your physical investment in a particular jurisdiction, and whether the state has properly provided police powers in terms of protecting your investment. This is certainly the example I just spoke about in AAPL versus Sri Lanka, and I was dealing with at the time was dealing with sort of terror attacks on AAPL's investment in Sri Lanka at the time. This is going back to the 80s, and sort of the consequence of some of those attacks on those physical investments, and sort of Sri Lanka being then liable for the actions of those within its territory, or its failure to protect against those acts against the investment. The other one, which comes up quite often, is also fair and equitable treatment. This can also be something that comes up for contractors or owner-operators operating in foreign jurisdictions. This typically can be viewed in terms of the investor having, depending on the formulation and the definition in the treaty, deals with sort of legitimate expectations that an investment will be afforded by the host government fair and equitable treatment. And the failure to do so may affect, and may be coming in the form of, there was many described as sort of rug pulling. So the clear example that I was sort of involved in for a while was in relation to sort of the introduction of new tax regimes, that the consequence that sort of affected the investment of my clients in another jurisdiction, and these changes to sort of tax regimes were done retrospectively, so there was no way for the foreign investor to be aware of it, or to have anticipated or had foresight as to sort of the changes in the legal regime. For a contractor, this also may be changes in licensing regimes and permit regimes in terms of their securing of the site. They had come and procured a site, got the necessary permits, but then a change in the law unexpectedly reverses all those permits, or reverses their ability to perform the construction in the jurisdiction, may fall under the category of an FET, or a fair and equitable treatment claim. Those we regard in many terms as absolute protections. There are others that are called relative protections, and many of those who are familiar with trade law will be familiar with these ones. These are the MFN, or national treatment. So a host state may not treat the investment of an investor less than the treatment afforded to third nations, or in national treatment context, they may not be treated differently from the citizenry or a national of the host state. These are sort of very basic base definitions of this. The final one I'm talking about, which is also relevant, especially in the construction context, or umbrella, or some called elevator clause protections. This certainly is important for contractors. It allows for what would traditionally be known as a contractor claim, based on a commercial construction agreement, to be elevated or brought under the umbrella of an investment treaty, where you're able to take a commitment given by the state, or an attributable state entity, that allows for that construction claim to then go up to being a treaty breach. And so it's a very, the cases that have been brought typically have relied on an umbrella clause in the relevant treaty to take some of the contractor claims and raise them to the level or the plane of an investment or an ISDS claim. So it's always interesting to sort of see how these sort of are interpreted by tribunals, and whether that particular contractor or investor has properly invoked the umbrella or the elevator clause in a particular treaty. Given time constraints, I'm not able to sort of go into sort of textual discussions on this, but it certainly is an interesting area, and certainly something that should be looked at in the construction context. Now, the other bit that's also really important that I'll quickly want to come on to are jurisdictional requirements and also state responsibility, and they're very relevant in the construction context. I think it's important. Investment is that we need a treaty to provide for what qualifies as an investment that can be afforded protection under the relevant treaty regime. Traditionally, and I'm trying to pull up an example from a TAI treaty. So if we look at Article 1, so Thailand has actually very recently, in the past 5 years, entered into a bilateral investment treaty with the UAE, the United Arab Emirates, just in 2015, which came in force in 2016. Article 1 of that treaty defines investment as a foreign direct investment made by investors of one contracting state, so we say Thailand, in the territory of the other contracting states, so let's say the United Arab Emirates, the UAE, in accordance with the UAE's laws, so the latter's laws and regulation, and includes every kind of asset, particularly but not exclusively, and there's a variety of different types, so movable and immovable property, shares and stocks, rights or claims to money, intellectual property rights, business concessions, licenses, authorizations, permits conferred pursuant to laws and regulations or contracts, concessions to search for, cultivate, extract, or explore natural resources shall not be covered by this agreement in both countries. So you can see in the construction context, it's not unusual for a contractor to require either an infrastructure or construction deal with concessions, licenses, authorizations, and permits that may be conferred. So this would be whether a Thai contractor operating in the UAE who obtains lawfully particular concessions, licenses, and authorizations and permits to conduct its business within the UAE would be looking at that type of category of investment under the context of this particular treaty, should there be an issue. It's also very important. What we call this sort of an asset-based definition of investment. The other form, which has been emerging, is more of an enterprise. It requires more. So the new treaty regime released by the Republic of India has moved to more of an enterprise definition, which means that the contractor would have to have a much more established presence in the jurisdiction before it would necessarily qualify as an investment. And certainly if you're in the context of ICSID, that's where both contracting parties are party to the ICSID Convention, and therefore the treaty arbitration would be under the ICSID Convention. There are particular definitions of investment that have been developed by investment tribunals over the years, in particularly what's called the Salini test, and the requirements of establishment and commitment and duration of time in a particular jurisdiction before it actually qualifies as an investment. This is in addition to sort of what the language of the treaty has provided for. The other thing that's really important that comes up quite often is whether or not the contractor qualifies as an investor and is permitted protection under the treaty. Now, definition of investor can come in two forms. We see investors as natural persons, and that should be a national of one of the foreign state, and not a national of the other state. And then there's also juridical definitions. So basically, and this would be in the context of a contractor, like a contractor is a company, whether a juridical person. So looking at the ASEAN Comprehensive Investment Agreement under Article 4, 4E, a juridical person would be a legal entity duly constituted or otherwise organized under the applicable laws of the member state. So this would be a Thai contractor duly organized under Thai law, whether for profit or otherwise, and whether privately owned or governmentally owned, including any enterprise, corporation, trust, partnership, joint venture, sole proprietorship, association, or organization. So you can see the definition is quite broad, and how a Thai contractor could necessarily fall within the definition of investor when operating under the ASEAN Comprehensive Agreement. The final thing I want to talk about on this slide before moving on to sort of the future of investor-state dispute settlement is state responsibility and attribution. These are quite important sort of issues, because not every grievance that a contractor might have in a foreign state necessarily falls under the protection of an investment treaty, or may go to investor-state arbitration. Just because you really have to be looking at an act or omission against the contractor as a foreign investor that is attributable to the host government. So, as I used the example of the Thai contractor operating in Malaysia, before that Thai investor could go to investment arbitration or ISDS, they would have to be able to demonstrate or show to a tribunal that what happened to them is the fault of, or is the responsibility of, the Malaysian government or the state of Malaysia. So in the case of AAPL versus Sri Lanka, AAPL had to demonstrate that Sri Lanka was responsible for not protecting its investment against terrorist attacks back in the 1980s. So there is that threshold that needs to be met, or that level of state responsibility that needs to be demonstrated and shown. And there are various different instruments that are out there to sort of demonstrate the definition of what will qualify as sort of the level of attribution and state responsibility. The clear one that a lot of us refer to, either in terms of as a source of law, are the International Law Commission, the ILC's articles on state responsibility, and we all refer to sort of Judge Crawford's commentary to those articles, which give sort of definitions of what would necessarily be an act of the state. So clearly, if the military of one country went in and commandeered and took the investment or nationalized the investment, then we would have a clear connection between responsibility of the state, because usually an organ of the state usually triggers the responsibility of the state. But then where it gets a little more tricky is when you're talking about different types of actors that may be operating inside or outside the government, or acting with governmental authority, which then makes it, in terms of factual matrix for the investor, to demonstrate that conduct should be imputable to the state, and therefore subject to the arbitration and the tribunal's authority to rule upon it. So these are, so while we talk about ISDS in the context of providing for another forum for construction suits to be dissolved, I think we need to sort of be mindful of the different sort of issues that sort of arise. Certainly state responsibility and attribution are one of those. So very quickly, turning to my last slide, the future ISDS, we've talked a lot about the history. Surprisingly, what has happened over the past few years has been a backlash. So as I said earlier, one of the first publicly known cases is AAPL versus Sri Lanka from 1990. That's only been in existence since 1990. Case sort of came to fruition in the 80s, and the award came out in 1990. It's only been so many years since we've had sort of actual investment arbitrations, yet there's been a lot of backlash that we've sort of seen, both in terms of states' involvement, but also the acts of foreign investors and what it means for states to be subject to some of these investment arbitrations. I think one of the more key criticisms that's come out in terms of against ISDS is it's created regulatory chill, because if you have foreign investors second guessing or dealing with bringing claims based on the regulations of the host state, then host states start they think twice about whether to implement the regulations. But these regulations that we're talking about, in many ways, can be within the sovereignty of that state, and are certainly for the betterment, in many ways, of their own citizenry. So a clear example of this this power is in relation to taxation. There may be issues of sort of whether or not the state has properly exercised its tax authority. That's a very clear example of where investment arbitrations have arisen. But they're also in terms of regulation of the environment. So maybe the reason why certain projects or licenses have been taken away or have been extinguished, which does have an impact on contractors, is because there may be some environmental impact in terms of the project for which they were sort of unfolding. You take mining, for example. If the state decides that the mining operations are detrimental to the environment in its jurisdiction, it may decide to sort of, we don't really want to continue with this mining program, and we're going to retract all licenses. That certainly will have an impact on foreign contractors that are operating to excavate the mine, who've got the permits and so forth. But you can see how that it can have a regulatory impact. I've referenced Khan Resources in Mongolia. We talked a lot about mining extraction in Mongolia as a country. In that case, there was a settlement in the area of 70 million US. Now, I think that in the grand scheme of economics and so forth, 70 million may not be as large as some of the larger arbitral awards that have come out. I mean, if we take the Yukos award, that was $50 billion that was brought against the Russian Federation. 70 million is a fraction of that. But I think that we lose sight of the fact that for a country like Mongolia, $70 million can have a meaningful adverse impact on its sort of budget as a country. If I can recall the statistics correctly, $70 million settlement that they entered into was, I think, about 15% of the education budget for the country of Mongolia. So you can see it has in those terms, it does have an impact. I think that I'll turn on to pulling back before talking about systemic concerns, because I think that as a consequence, some states have taken drastic steps to sort of terminate their investment treaties. So South Africa is a very clear example, especially following the Foresti versus South Africa case. South Africa started terminating them. India did the same, but following the termination of its treaties, India started introducing a new investment treaty program that was more state-friendly to avoid issues of regulatory chill, and carved out particular regulations or regulatory powers by the Indian state or the other state that would not be subject to sort of claims. Reforms. So because we've had this backlash in the past 10 years, a lot of reforms have been introduced. I think one of the concerns that we certainly see this in commercial arbitration with construction disputes, there certainly are private and confidential either by statute in certain jurisdictions. The same can be said about an ISDS arbitration or investment arbitration. So I think that, but because of the element of state involvement, state authority, and regulatory authority that's subject to some of these investment arbitrations, there has been a move to provide greater transparency in these disputes. Certainly in the context of NAFTA, investment arbitrations that were brought under NAFTA were public, hearings were public. The United States government, through the State Department, publishes the submissions in these cases unless there's a reason that the parties have agreed not to. So the transparency can be quite important, because I think the citizenry as well as foreign investors want to see what is the consequence and outcome of some of these cases that have been brought. So there's been a push for transparency so that people know. As my bullet point above, it's to avoid what we call justice behind closed doors. I think when you're dealing with a contractor and an owner-employer, and you have a commercial agreement with a commercial arbitration, it's one thing to not want to air your dirty laundry via a dispute in a public arbitration. But I think that when people talk about taxation, environmental protection, and protection of it's sort of the borders, people, citizenry, subjects of particular countries do feel that they have a public interest in sort of the outcome of some of these arbitrations, hence the push for transparency. And you'll see that certain bodies, international and intergovernmental bodies like Icsid under the World Bank, Untitled, which is under the United Nations, have been looking at various forms of reforms of the investment arbitration regime. And this, coming to my last point, is sort of what lies ahead. I think that a lot of ideas have been floated. One of them I've highlighted is whether or not we should have an investment court rather than have arbitration as a dispute resolution for some of these disputes. So it's not doing away with the treaties themselves, but maybe changing and having all member states sign up to sort of a multilateral investment court where you would have a roster of judges and you would have deal with it just like you would with like the International Court of Justice, where foreign investors could then go to that court under the treaty regimes and then bring it, and then they would have them resolved in a more public forum. I think people associate courts with transparency a lot more, but there are other reasons why people are looking at courts. So I think it's still a wait and see in terms of what happens. This doesn't mean that investment arbitrations have gone away. Thailand itself has been the subject of an investment claim that's in the Kingsgate case that was kicked off a few years ago. And so I think that people are in Asia, especially countries like India and Korea, South Korea, have been the subject of very recent investment arbitration claims that have been brought against the countries. I think India is facing maybe 24 to 27 claims. And in the past 2 years, South Korea has probably received maybe between 6 and 8 new investment claims that have been brought by foreign investors under various regimes. So as I said, it's sort of a wait and see. A lot of institutions like Icsid and Untitled have taken up the initiative to sort of move reforms. We'll see how those reforms unfold and what ultimately becomes, I guess, a new system for resolving these disputes. But I leave everyone with those thoughts. Happy to field questions at the end of this webinar. Also, feel free to contact me directly if you have any questions.
Thank you, Wesley. That is very interesting. Okay, that is very interesting presentation. I think that for this kind of ISDS arbitration, it will be the trend and also the issue that the participant would like to hear. And also you share lots of useful information today. And actually, as you said that refer to the king case against the Kingdom of Thailand, all Thai people know as the Akara coal mining cases. I think that for this case, many Thai people looking very interesting to see and to know how the case will be end. Either I don't know, maybe settlement or maybe with the arbitral war. There are so many issues involved with this, and Thailand have less experience about the investment arbitration. I think from my research, maybe like 3 cases. First case could be a waterbound case that the German investor, they pursue the case against Thai government. And I'm not really sure about the second case, but then we have this king case as the third case. So we can discuss about this later. I hope that some of our participants may have some question about your presentation as well. But anyway, very excellent presentation. So right now I will take another like 20 to 30 minutes to present my presentation about the international construction arbitration. It's actually concerning the construction claims for extension of time and additional cost due to COVID pandemic. Let I stop your presentation first. Okay, I think that yesterday we heard about the good news that Pfizer already have successfully invented the COVID-19 vaccine that have the very high successful rate, and also that probably would be available in the market by March next year. So that would be a good news for everyone, right? So my presentation separated into 3 parts. The first part I will talk about the COVID-19 pandemic and the force majeure under Thai law, and then I will talk about how and what kind of the remedies and how the party in the construction dispute can request for the time extension and as well as the additional money caused by the disruption of the COVID pandemic. And my last part will include about the kind of the mechanism that in case that you terminate the contract and the employer want to take the money from the performance bonds, how we going to do under Thai law. So as you can see that WHO World Health Organization, they has announced the COVID-19 as the pandemic. This term is quite important because actually before this COVID-19 become pandemic, they called the disease as the epidemic. So epidemic is just only the disease that has been widespread from some places, but for the pandemic is more areas, and especially they use in the special occasion that is spread around the world. So that the impact is really important, and this term is really important in case that you want to use this term and then you refer to the WHO announcement. So you see, as you can see, the effect of the yesterday report from the infected Yesterday, infected number is already 51, approximately 51 million, and dead 1.2 million. So that is something is very high number. So right now, as you can see from the statistic, that the death still going on even right now, 1.2. And the first case, as you heard about it from the news, is that the infected in Wuhan, China, happened to be at the end of December last year, right? At that time, no one know what kind of COVID-19, and once before the Chinese New Year, everyone just thought that, oh, why China locked down the country? For myself, I even very surprised that China, they have like built the hospitals in like 2 weeks. Alert me that, oh, this disease would be this pandemic would be the big issue. Otherwise, the China won't announce for the lockdown. But for many businesses, we discussed from time to time in the early of the pandemic that is this should consider as the force majeure. I think at that time nobody. I think not everyone agree that COVID-19 would be considered as the force majeure. From what is the reaction of the Thai government, as you can see that why I highlight the date, because this is important. Thai government announced the state of emergency on the 26th of March this year, and right now we still under the state of emergency. However, the measures, the health measure that the government announced already relaxed, because during March until May, the government also imposes several measures. For example, not allows the malls or theaters to open. Just only you can pick up your food from the restaurant. You cannot eat in, something like that. And for some provinces like Phuket, or the key tourist destination had seemed to be like locked down, because the government screen and not allow everyone to just cross to the province. That is sometimes that is something that caused the problem to some businesses. I think that not except construction, because of construction, sometimes you want to move your material from province to province. That is difficult, because you have to do it before 9 p.m. Otherwise, you cannot move your materials to another province, something like that. And on the 14th of June, curfew had been cancelled, so everyone can move across the provinces. These days, this period is very important when you want to claim for the force majeure. You cannot claim for force majeure until next year, even though you can say that right now we not COVID not gone yet, but you have to give the detail and the duration of the force majeure that affected your company. So why I say that COVID-19 is considered as the force majeure under Thai law now? Because on the 24th of May, but actually since the end of March, the committee of March this year, until the latest announcement from the Committee of Government Procurement and the government procurement and the supply management issues the letter as the guideline to the administration of the contract, that if the government unit or the state enterprise have the contract, so they should during the COVID-19, what should they do? Okay, to amend the contract or to consider to reduce the liquidated damage or to postpone for the handover of the work, something like that. In that letter of the committee, they say that COVID-19 is the force majeure. This kind of letter is the public information letter. And also other government units also made the announcement, like the Office of the Labor Welfare. They also announced that COVID-19 is the force majeure. So this is the kind of evidence that you should collecting if you want to claim for the force majeure. Why? Because under Thai law, the definition of the force majeure under the Thai Civil and Commercial Code does not explicitly provide what is the result of the force majeure. If the law only say that what does it mean? What the definition of the force majeure under Thai law. But if you want to claim for the exception of the liability due to the force majeure, then you have to rely on the section 219 of the Civil and Commercial Code. For this section is claim that if the situation that prevent you to perform the contractual obligation, for this one you can, and it is not your fault, then you are not liable for the breach of the contract. So as you can see that since Thailand is the civil law country, we don't have the frustration or the hardship court case precedent. However, I would recommend you, if you want to claim for the force majeure, first you go to your construction contract. That usually FIDIC, for example, if you use FIDIC already provide what kind of the force majeure event that include, and what is the remedy under the FIDIC, something like that. So the construction contract that you probably have the force majeure clause that provide several details that can help you to analyze whether or not you have the right to stop perform the contractual obligation or to suspend your work during the disruption of the pandemic or to terminate the construction agreement. Okay, for some country like China, they also issue the force majeure certificate. For this one, I think also is quite useful for Chinese company that they can claim to that maybe foreign contractual party that during the January until February they cannot perform the contractual obligation because it's force majeure, and therefore they can show this government force majeure certificate. So you don't have to collect the government announcement, government letters as issued by several Thai government like I referred to previously. But anyway, this kind of document is available on the internet. That if you, I think it's still available right now. So if you think that your business would claim for the force majeure, this is the document that you should keep in file. Okay. Yeah. Even though the Chinese government issued a force majeure certificate, however, for between the party, they probably have their own force majeure clause that if they go to the court or arbitration, foreign arbitration outside China, that force majeure clause will be applied instead of taking a look to the Chinese government force majeure certificate. Because that force majeure certificate doesn't mean that Chinese party they can be released or not liable forever during the pandemic. Because as you can see from the certificate, they also put some of the duration, right? And China have very good record that they can finish they can solve the problem of the pandemic like 3 months from January until March, and they lift up all the measures in early April. So what kind of the impact of pandemic on the construction, as you can see, and like several government restrictions right now, even in Europe, they still have the lockdown until the end of November or even 15th of December, right? So if you have some material that probably you need from this country, that would be unlikely that you will get it on time, right? Or even you have the agreement that you will send somebody to train in Europe. That could not be possible right now. So this kind of the travel restriction, the curfews or social distancing is something that could delay the work and limit the number of laborers. I think in Thailand, when Myanmar have a lot of infected COVID people, we also have the problem. Why? Because right now our construction laborers from our neighbor country, they gone back their home country like Cambodia, Laos, and Myanmar. So that would be affect a lot to the construction business in Thailand as well. Yes, at the shortage of the supply, as I told you that if your supplies or material have to be in order from some country like the Europe or even the US right now, that not be possible to arrive into Thailand on time. But for site closure in Thailand right now, we don't have the lockdown, so we don't have the site closure unless that the site have to be closed due to the limited number of the laborers because not enough laborers to do the work. Then the site have to be closed. That's another thing. So what kind of the remedies for the pandemic? So I asked you to look at your construction agreement because that is the first thing that when you want to know about the remedies or the legal resolution. So you look at to your construction contract or your handmade construction agreement. You can see that when you can ask for the time extension or additional cost due to the disruption. But another remedy for non-contractual remedies, you can check from the governing law that usually the construction contract will say that, okay, you as the Thai company made the construction agreement with a Singaporean company, then what kind of the governing law could be a Singapore law or Thai law whatsoever that you also have to check in your contract. And also again for the force majeure, in some country like Thailand, we provide only the definition of force majeure, but not the result or what kind of the result if you claim for the force majeure. And for the frustration, hardship, impossibility of the performance, this kind of thing maybe is put as the separated clause in your contract, or if it's not, then you have to look into the governing law. Okay. If you claim for the force majeure, it's due to the change of the circumstances, right? Because right now, if your construction require the marble from Italy, that would not be possible. Then you have to talk to your contractual party whether or not you can change from the marble from Italy to be the marble from China, whatsoever, that in order to deliver the work on time. And also same thing as the violation of the contract that's caused by the disruption. So if you ask the contractor what is the important that you should consider, again, carefully analysis the contractual remedies first, and then you have to mitigate your loss. How to mitigate your loss? I think you have to go to issue the notice, timely notice. That usually the construction contract or the FEDIC always say that once you aware of the disruption event that prevent you from performing the contractual obligation, you should issue the notice to your contractual party, right? And this kind of notice, it should be the detailed notice why you cannot do it and how the disruption affect you, right? And especially and what is the request to your contractual party. For example, you want to amend the agreement, you want to suspend the work, or you want to terminate the construction contract because it's not impossible to perform. Okay. To request, I think when I talk to notice to other party, I mean that the request or the notice that can be more than one notice or more than one request, because you can always update your request or your notice from time to time. And you can see that the pandemic is take time now, is 11 months right now. So probably if you request for amendment, you may have the monthly notice already, right? And the claim for the time extension, it doesn't mean that you have the right to claim for the losses and expenses caused by the delay and disruption. Because sometimes when you claim for the time extension, your contractual party your employer give you the extension, but they still reserve the right not to give you the additional cost, something like that. So that have to be very careful when you negotiate with the employer or the project owner. So this is a FIDIC Red Book 1999 about the extension of time. So I will go very quickly on this. And as you can see that the FIDIC contract also allows that the contractor can request for the extension of the time. So anyway, your employer will have to consider whether or not this is fit into the unforeseeable shortage of goods. You can see that epidemic. So I think it also includes pandemic right now, because pandemic have the greater damage, cause the greater damage than epidemic now. And also the governmental action. As you can see that the pandemic probably not affect us as much as the government's measure, right? Curfew and travel restrictions, something like that. And that 8.4E also include the delay or impediment that prevent the contractor to go to the site. So I go part through. Okay, then you you will consider whether or not you going to suspend the work or you want to terminate the contract. Usually when the contractor requests for the amendment during the disruption, and if the employer disagree, what happened? Usually the contractor will, the employer will say that, okay, if you not work, I am not making the payment for this and that installment. Then it happened that the contractor is entitled to suspend the work. And if they maybe during this pandemic, some of the construction contract already overdue, so it means that over the deadline. So the thing that you may consider whether or not you just let the contract proceed valid, but you may have to facing with the liquidated damage or the fine payment every day, or you consider to terminate the construction contract, something like that. So the tip for claim for the extension and additional cost, I think that timely notice is very important to establishing the facts in the detail in case that you can disagree with the opposing contractual party. It is not the notice and the request without information. If you want to claim for the force majeure, it is important to say that what kind of force majeure is the pandemic itself, or is the government order, government measure that cause you not be able to perform your obligation. And then you said in your notice that what time you need for the extension. As I told you that the extension can be updated. The time that you request for the extension in last March, now you have to change from month for 5 months. It can be 6 months right now, because even though you can travel, but some of your materials still over there in the US, for example. And the additional cost, what kind of cost, you have to detail it, and also keep the supporting evidence in case that the opposing party want to review it. And yes, the request for the variation is also important to include with the detail. That's something. Okay, and the last issue that I would like to discuss with you, that in case of the contractor cannot perform that duty on the construction contract, it's possible that the employer or the project owner want to call for the money from the performance bonds. What is the solution in here? So in this case, the contractor may attempt to apply to the court for an injunction to resist a call on an unconditional bond. This is the thing that you may consider to do it, because usually BG issue in Thailand, they not put the arbitration clause on the BG. So you have no choice. You want to stop the bank to release your money, then you have to go to the court in order to obtain the injunction order. However, it's not always the case that you can get the injunction, because in our experience, for some cases, sometimes Thai court believe that construction contract and the BG is separate, so the court don't have to waiting for the result of the arbitration, but just order the bank to make the payment to the project owner or to the employer. So this is the the thing that I like to show you, because this is the process of the ICC arbitration. So as you can see, when the employer or even the contractor the party in the construction contract want to proceed with the arbitration, right? But when they want to proceed with the arbitration, and as well as they want to obtain the injunction or injunction order, that would be difficult. Why? Because in order to obtain the injunction order or the interim measure, they have to wait for the constitution of the arbitral tribunal. However, this it could take like 2 to 3 months in order to set up the nominate and appoint the arbitral tribunal. So what happens if you cannot agree to appoint the arbitral tribunal? So maybe your opposing party may remove the asset that you want to enforce after you win the case, something like that. In this kind of thing, ICC already, and I think not only ICC, SIAC, and other institute, they already invented the mechanism to help the claimant in order to obtain the emergency interim relief by having the emergency arbitrator. The emergency arbitrator can appoint within 1 or 2 days in order to consider the application for the interim measure. So this is a quite useful thing, that if you want to obtain the injunction order, you can request to appoint the emergency arbitrator, and then this emergency arbitrator can consider to grant the interim relief for the claimant. However, after that, after the constitution of the arbitral tribunal, the emergency arbitrator will finish that job, and the actual arbitral tribunal will also have the right to review the interim relief again. Okay. So, but in Thailand, what happened? In Thailand, even though the TAI rules allow you to allow the tribunal to grant the interim relief, however, as we experience and we interview many arbitrators in Thailand, they say that okay, they have the power, yes, under the TAI rules, but however, they never use it. Why? Because the claimants go to the court, go to Thai court, and to obtain the injunction order from the court. That would be easier and quicker. But for this case, is something I like to mention to you, that you can consider the section 16 of the Thailand Arbitration Act, that even before you commence the arbitration procedure, you can go to the court and request the court to issue the emergency injunction. You don't have to submit your notice of arbitration to any institute, but you can do it later. But you can obtain the court order. After that, excuse me. After you obtain the interim order, you have 30 days to commence the arbitration proceeding. So some of the foreign practitioners also may criticize this process, because they may say that, oh, if you go to Thai court, then the confidentiality nature of the arbitration would not be upheld, something like that. But I like to share that we can request the court for the closed hearing. So it means that the court not allow anyone to attend the hearing during, because usually the hearing for the emergency injunction is the ex parte hearing or unilateral hearing, so that it will be keep the confidential. So that all I think I like to share with you, and the thing that I like to share here. Yes, for the we have key arbitral institute, Thai Arbitration Institute, and THAC, Thailand Arbitration Center. So, but TAI is the oldest arbitral institute in Thailand. Okay, and right now for the emergency arbitrator, as I told you that both institutes have no this rule. Yet we can go to the court to obtain the emergency injunction, and the expedite procedure or the small claim procedure. Yet for both institutes, they have this solution for you in case that your claim is not the high amount, so you can go to the small claim procedure, and the multiple contract and consideration. So no rules on this one, and the joiner as well. So, but early dismissal and the tribunal to grant the interim relief, yes, TAI have, but I don't think THAC have the thing called to confirm the tribunal power to grant the interim relief. And for the tribunal to decide on the counter suit, right now, no, the TAI and THAC have no rules on this, and the tribunal power to penalize against the delay tactics. I have to say that the arbitral tribunals in Thailand, they never impose the penalize against delay tactics. Why? Because they believe that they have no power. So, but if this happens in SIAC or HKIAC that you want to adjourn the hearing, then you have to inform your client that you have to prepare a lot of money for the expense and the loss of the other side as well. So for this one, I think that for the tribunal power to penalize the party that use the delay tactic is quite important. If the institute want to have the efficiency of the arbitral tribunal, so that are the things that I like to share for my presentation. And so it's already noon now. So anyone have any question? Okay. I have one last question for you, Wesley, before we close our webinar today. Your ISDS case that since for my research that most of the respondents came from the developing country, that they have to welcome the rich country, right, to invest in their country. And is there any but for the from the rich, have they have any concern when they suing the government? Because I believe that they still want to continue their business in the host state, you know. Because at the same, like the commercial dispute, when sometimes my foreign client ask me if I sue the government, can I will be a backlist, or the government may have some case counter claim against my business, something like that. Is that happen in your case, and how you advise your client?
Yeah, that's a very good question. In my experience and the experience of my colleagues and at my previous firm, embarking on an investment arbitration or an ISDS claim is not taken lightly. It is a very, usually an investor has to be in a very difficult position where they are kind of forced or compelled to bring the claim for the reason that you just mentioned, because especially if an investor, for example, mining, if we took that as an example, and you can only extract a particular resource from a particular part of the world, and you decide to sue the country where that's located, you in many ways may be giving up access to that source of mineral because you've brought it. So countries don't like being sued, and they don't like being sued in a very public way. So some countries, so if you did take the ultimate decision to bring an ISDS claim, you may be looking at closing off your access to that market once you bring that arbitration. So it's very important. You mentioned very briefly about counterclaim. That's actually a very interesting topic that has been arising more frequently now in the context of investment arbitration and whether states have jurisdiction or a tribunal has jurisdiction. Some treaties are very explicit in terms of whether they allow for counterclaims. Some have been quite flexible in the language, and they do allow for counterclaims. So I wouldn't say that this is it's not necessarily a cut and dry issue. It really depends on the text of the treaty, but it is something that should be explored or be mindful of if you are the investor, that whether there's the ability of the state to actually bring a claim against you.
Okay, thank you for your clear response and information. So I have one participant asked, how do you think about the ex parte procedure in issuing of interim measure by arbitral tribunal? Okay, I think, okay, for in Thailand right now, we don't have the arbitral tribunal issue the interim order, interim measure, because as I told that, yes, if we obtain that order from the tribunal, we still have to go to the court to enforce the order, right? So that is made cost more work to and also increase the cost for legal fee for the party who obtain the interim order as well. But however, if your opposing party have the asset to be enforced in Thailand, yes, I think it's better to go to Thai court. However, if you are, for example, the performance bond is in Singapore, for example, if you go to Thai court, you obtain the interim, the injunction order. Thai court order cannot enforce in Singapore, so I think it's better you obtain the order from the tribunal and go to Singapore. That would be better. And for the ex parte or the unilateral, I heard from I have some experience from SIAC that usually for the interim release, for the interim measure, they will invite the other party to join before the tribunal to grant the order. So that is my answer. So Wesley or Mr. Wang Li, would you like to share any idea?
Yeah. So on I think it's a very interesting point because seeking interim relief or conservatory or preservatory measures is very important, especially if you're the claimant, because you want to make sure that assets at the end of the day can be preserved for enforcement once you get the final award. It's also, especially in a construction context, and I've had to deal with this as well, is also preservation of evidence. So if you're a contractor and you've been kicked off site by the utility or the owner operator, that means that you lose access to project documents and so forth, and you need to make sure that that evidence is preserved so that you can use it in the arbitration. If it gets purged or whatever happens, that can be quite detrimental to your case from an evidentiary perspective. Now, so going back maybe about 10 years ago, both Singapore and Hong Kong, to take them as examples, enacted legislation in their local arbitration law to allow for the enforcement of arbitral awards and orders from emergency arbitrators, because institutions that we're familiar with, like the ICC, the HKIC, and SEAC, had introduced emergency arbitrator application procedures to allow for interim relief to be granted prior to the constitution of the actual tribunal in a particular case. So in the context of HKIC, it's Schedule 4 of the Administered Arbitration Rules, which sets out the procedure in dealing for an emergency arbitrator application. Hong Kong law and Singapore law enforce such interim relief. One thing I would like to add, which is a very recent development in relation to Hong Kong and mainland China, last year on October 1st, a special arrangement entered into force whereby arbitrations that are seated in Hong Kong and administered by a qualified institution like the HKC or the ICC in Hong Kong may seek from a Chinese court in the mainland interim relief in support of arbitration. Prior to this, and similar to what you were describing in Thailand, you would have to only go to a court to resolve your dispute, and only a court could grant the interim relief. This allows foreign parties who have arbitration seated in Hong Kong, administered by institutions like the HKC, now to seek, if their counterparty is based in mainland China, to preserve assets, to preserve evidence, and to preserve the status quo, again, relevant for contractors. HKC has received, I want to say, somewhere between 24 to 26 applications under this new arrangement, which came into force last year. And many of billions of dollars have been secured through applications made from the HKC through to the Intermediate People's Court in the relevant jurisdiction. So interim relief is, as you can see, relative, and you can see that different parties are making use of interim relief. And obviously, as you said, in terms of Thailand, another jurisdiction where you can't seek such relief is India, and you actually have to go to the courts as well too, and it can be quite costly, as you were saying, in relation to sort of Thai courts, because you have to bring a separate application. You then have to go before a judge, and and all sort of that process. I guess there's costs, and I guess it's also time, because you also need to wait for the court to grant that. On your point in relation to sort of ex parte, arbitration, as we know, is mostly a party autonomy and equality between the parties, and also sort of consensual process. As it stands right now, I can't recall the exact SIAC provision, but certainly under the HKC, emergency arbitrator procedures are inter partes. As you were referring to the SIAC context, HKC similarly as well too. When you file your application with the institution to seek interim relief under Schedule 4 of the Administered Arbitration Rules of the HKC, that is served on the other side. They will receive your application. In terms of timing, just to give you the practice of the HKC, since I was managing counsel there, the quickest the HKC, the fastest they were able to appoint an emergency arbitrator was 35 minutes. On average, it can be between 5 hours to 24. It relates to how much information may be sort of provided in the application to allow the institution to make that appointment. When the HKC introduced the 2018 Administered Arbitration Rules, it reduced the time for the appointment to 24 hours. So the rule provides 24 hours, and the time for when an emergency arbitrator is to resolve is 14 days. Previously it was 15 days, it's now 14 days. And they've also placed a cap in the rules on the compensation of the emergency arbitrator, which is provided on their website, which means that in order to keep costs low for parties in emergency arbitrator procedures, HKC is mindful of what it can cost in order to deal. This is separate from obviously legal fees, but we are talking about compensation of the arbitrator. Previously it was on an hourly basis and so forth. So I just, you should just be mindful of this. There's always a cap to be aware of in some institutional rules in order to keep costs down for the parties when it comes to emergency arbitrator applications.
Yeah. Okay, Mr. Wang Ling, you can share. Unmute, please. Unmute.
Okay. Okay, your view, your view on this emergency arbitrator, even I feel that this is very important because sometimes the parties are in emergency. And even if you go to the court, sometimes to get court injunction and then again to implement that takes time. But if you have these emergency arbitrators, they can, at least that emergency arbitrator, usually a sole arbitrator, can decide on certain matters which are in emergency or in need, and that will save time and cost. And later on, like the arbitrators, when tribunal is formed, then they can decide on this matter to entertain or not. But I think it's going to save a lot of time and cost. And we are also thinking now that we have to introduce this emergency arbitrator as a backup. So because sometimes to form an arbitral tribunal takes time. But before that, I think the emergency arbitration is very important. We are also discussing on this and trying to now introduce this to our new rules, revised rule is very important. I feel that this is very important, like Singapore and other arbitration centers, they have this, and we have to introduce this. And other thing is that regarding this, the consolidation of the claim and the gender of the parties, emergency arbitration is very important. We are also discussing on that, and then the arbitrators will have to look into it. If it saves time and money, I think parties should put together, because there is a consolidation of the claims. This provision are there, but parties should use that, and arbitrators should also explain to the arbitrators and to the claimants that it will be good for them. So I think pulling of these cases will really save time. And we are also now encouraging this. We'll want to encourage this, and even through online arbitration now, since parties cannot meet in person, to use this is very important, which is in the rule. But we want to enhance this further and make this more viable, so that people can take advantage of this. Other is that about the counter suit, I think is also very important, because that has to be determined. We cannot give people what they want and how much unless that is proven and all. Other thing is that, as you said, that regarding the delayed practice, usually by the respondent, because they don't want to pay off the money and then no bad time, and they really delay the practice, and because of that, we lose a lot of time and cost. And for that, I think we are also now looking very seriously into this matter, so that people could be disciplined, and that there will be fair justice at the end of the day. So these four factors are very important, and ultimately now I think, as Wesley has said, that this using treaties, the bilateral, multilateral treaties are very important, because the states can do a lot in this matter, and I think individuals as citizens should take advantage of the treaties and convention, and that I think we need to now explore more, so that especially at this period of time. So this is what we are also trying to do at Higher Arbitration Institution, and all information that we receive from this webinar has been very useful, especially at this time when we are revising the rules for the further development. So thank you so much. This is what I want to express.
Yeah. Okay. I think that it's now the time for close the webinars, and I'm very enjoy discussion with both of you, Wesley and Mr. Wang Thi, and I hope that this is not will not be the last time, and we will continue to have the discussion, and maybe in the share in the same panelist again. So thank you very much for your time and your great contribution, and thank you for all the participants who are attending this webinar. And that information will help our TAI to be more efficient, and also to have to be the useful arbitral institution for the foreign and Thai party. And thank you very much again, and see you next time. Bye bye.
Thank you. Thank you so much. Bye bye.
Thank you very much. Thank you, everyone. Thank you.
Okay.
Bye.
See you next time.